Canny Maphanga speaking to AfriForum. Let's take it there live.
Discussed it. We have already decided such, and we are concerned that we live in a political system, in a country, in a legal system where it's quite obvious, or this ruling makes it quite obvious, that when a leader of a political party blatantly and openly romanticizes violence towards minority communities, it's condoned and it's accepted by the courts, and that's something we cannot accept. That's not a symptom or a sign of a free democratic system. That's a sign of an oppressive system, and we must be very cautious of political systems where violence towards minority communities is accepted and seen as something that's not quite as condemnable as violence incited against the majority. That's a very dangerous route. It's a slippery slope, and that's why we will file an appeal.
And when you say there are
errors. Yeah, so one thing that we were a bit concerned about in the judgment is the judge gave very strong emphasis and highlighted several times the issue of a link between chanting "Kill the boer, kill the farmer" and farmers being murdered, despite the fact that throughout my testimony, throughout the arguments given by our legal team, we have repeatedly stated that the test of whether something is hate speech does not depend on whether there is a causal link. The judge, at least from his summary, it seems to us as if he thinks that you need to prove some form of a causal link. Well, that's not what the Act says. That's not what our argument was. So it seems to us that the judge didn't really, at least in his summary, didn't give a proper evaluation of our argument. And he seems to have dismissed an argument that we didn't present to the court. So we are concerned about that. And also we don't think the ruling is consistent with what was already decided by the Constitutional Court in the Kwalani matter, which was also a hate speech case.
How do you feel about you not being a witness that this matter could rely on, and with all other of your witnesses as
Yeah, well, that's one aspect that's not consistent with what the Constitutional Court has already decided. In the Kwalani case, for example, it was a hate speech case, particularly regarding hate speech against the gay community. And in that case, there were expert witnesses who were professors who were also gay, who spoke about their experiences as being gay and so forth, and it was accepted, as it should be. And now, when it's an Afrikaner testifying about his experience as, his experience in a community where his friends and people in his community have been murdered, then suddenly it's dismissed and it's not acceptable. So we are concerned about double standards. And I think what this also says to us, again, is that we will appeal. We will file an appeal. But other than that, it's very clear to us that if we want to have a future as a minority community in this country, we have to look after ourselves. And the answer is, if the legal system does not protect our community, we'll have to put our energy and our focus on strengthening our community safety structure so that we are physically able to defend ourselves when we're attacked, if the courts are not prepared to defend us.
So the judge saying that there's really no link here when it comes to the singing of the song. Previously, there was an explanation being done that Peter Maphanga sang the song.
Yeah.
But he's saying that the evidence you have brought on doesn't show that. Do you accept that?
Well, yeah, so I testified about research that we've done and that I've done personally with our team, of course, about a spike in farm murders after high-profile cases of hate speech. And I listed several examples. The one we put the biggest emphasis on was the case of Peter Maphanga, because it was this exact same song. And the fact that after he started chanting this song, which he popularized again, I mean, we know it's an old song coming from the struggle years, and I testified to that effect as well. But he then popularized it again in the early 90s. And then there was a sudden spike in farm murders and farm attacks after he started singing this song. So I testified about that to emphasize how serious we should take an issue like this. But that does not mean that our testimony is that we're trying to prove a link between the two, because it's not necessary to prove a link. If we did prove a link, which I think we did, it's not necessary for the question of whether it's hate speech or not. And I think if that is, of course, we'll read the full judgment, but if the conclusion of the judge is this is not hate speech because they didn't prove a link, then that's wrong. That's not what the Act says.
And what do you say about the judge saying that, while you say this is not hate speech, it can also offend someone?
Yeah. Yeah, well, it's obviously offensive, and in a sense I agree with the judge, and we agree with the judge, that we must be very cautious not to accept offensive speech as hate speech. Offensive speech is a reality, it's unfortunate, but it's part of democracy, and in a free system people will say things that offend each other. That does not mean that it's hate speech. The difference between offensive speech, when the question is whether does offensive speech become hate speech, and the answer is it's an easy answer. The answer is when it targets a particular community based on their identity, such as the boer community or the farming community or white people or something to that effect. It targets a group of people based on their identity, and then it incites violence, or it creates a situation where harm is inflicted upon that community. Then it becomes hate speech. And now if a political leader goes onto a political platform and says all white people are criminals, they have to be treated as such, if he testifies in court, I might one day call on my supporters to slaughter white people, and then he chants kill the boer, kill the farmer, and then the judge says no, that's not hate speech, it's only offensive. If that's not hate speech, what is hate speech? There's nothing left on the spectrum that can be hate speech if this isn't hate speech. Yeah, sure.
Sorry, and please join me closely as we wrap this up. Just to speak a bit in detail, you have said that you plan to appeal this matter. On what? I know you're going to release those details further, but if you could just give us a brief understanding on what grounds you're choosing to appeal this judgment made earlier today.
Well, what we heard today was just a summary of the judgment. So we will study the full judgment, and then based on that we will file our appeal. Our concern is what we heard from the summary so far is not, in our view, a proper application of the law in question in terms of what constitutes hate speech and what doesn't. In our view, this is a very clear example of hate speech because, well, it seems to us that the judge has put a lot of emphasis on the question of whether a causal link can be proven between Julius Malema chanting kill the boer and farmers being murdered. And that's not the test for hate speech. The test for hate speech is a particular community being targeted. You could say based on their identity. I'm simplifying the definition. And then, so are they targeted? And is something published or uttered that reasonably demonstrates a clear intention to cause harm? And now if this doesn't comply with that definition, nothing does.
Do you agree with the note or the finding by the court that hate speech must be balanced with the right to freedom of expression in this case?
Yeah, absolutely. I mean, freedom of expression is crucial. It's the courts in this country have said correctly that freedom of expression is a cornerstone. You might even say the cornerstone of a well-functioning democracy, and that's extremely important. Now the question is when is freedom of speech not acceptable, and that the answer to that question has to be a very narrow line. There can only be a very narrow list of things that do not comply with the definition of accepted free speech. And that's where hate speech comes in, where propaganda for war comes in, and stuff like that. And so when you talk about hate speech, it's outside the ambit of free speech.
And do you think you didn't take, AfriForum rather, took these chants and these songs out of context historically and took it a bit more literally?
No. In my testimony, I think also in terms of the summary the judge gave, he seems to have concluded that I and AfriForum, that we're not aware of the history of this song, which isn't true because I testified about that. I testified about the fact that this is a struggle song. It was sung during the 80s and perhaps even the 70s. So I don't know if the judge just missed that, but he clearly doesn't seem to remember me saying that, but it's on record. So yes, we know it's a struggle song. We know it was chanted during the struggle. The fact is we live in 2022 now. And now the question is, how do we deal with a song like this in the year 2022? And we have very clear laws on hate speech and what doesn't constitute hate speech. And we cannot have a situation where the question of whether it's hate speech is determined by the race of the person uttering the statement. So if it's a white person, it's hate speech, and if it's not a white person, it's not hate speech. That's obviously not a system that we can tolerate.
All right, thank you so much, Ernst Roots. We will continue that conversation in a few minutes as I wrap up to studio. That was AfriForum's Ernst Roots, who was just expressing disappointment today after they lost their case against the EFF to declare the chant, or the song rather, of Kiss the Boer, Kiss the Farmer, hate speech here in the court. It's still a hive of activity out here as EFF supporters continue to celebrate this judgment. We understand that AfriForum is planning to appeal this judgment that they've lost today. Those details will be released later today. Over to you in studio, Desiree.